Holy Cross College, Agartala, respected faculty members, and my dear beloved student participants. It's a great honor and privilege for me to welcome you all to this one-day online national level seminar on protecting artificial intelligence intervention under current intellectual property law. The event is organized by the Department of History, Holy Cross College, Agartala, in collaboration with the Internal Quality Assurance Cell, Holy Cross College, Agartala, and the Department of Business Administration, Holy Cross College, Agartala. Now, it's a great opportunity for all of us to enrich ourselves from our respected chief guest and keynote speaker. So, without much delay, I would like to request our principal, Father Dr. Benike John, CSC, to kindly deliver the welcome address. Father, over to you, sir. Father.
Thank you. Can you hear me?
Yes, Father.
Honorable Vice Chancellor, Professor Yogesh Pratap Singh, Ji, members of the faculty and dear students, a very good morning. I am privileged and it is my honor and duty to extend you a warm welcome to this workshop. It's an important topic, protecting AI intervention under current IP law. The Department of History and the I.Q.A.C. together have wisely taken decision to organize this important workshop. On behalf of all of us here, especially management, we are grateful and acknowledge Professor Yogesh Pratap Singh for your time, your goodwill, and readiness to share your knowledge, time, and your experience, especially with our students and faculty members, with all of us, to enlighten us and to also enrich our own academic search and academic efforts. Thank you, sir, and I congratulate and acknowledge the Department of History and I.Q.A.C. once again for your effort and your hard work. Dear students, I also extend you a warm welcome and exhort you to give the best attention and participation to benefit the best out of this workshop. Thank you, one and all, and have a good day. Thank you. Over to you.
Thank you, Father, for your kind words. Now
Yes,
I would
Father.
like to thank you, Father. So now I would like to request Madam Sharmili Chakraborty, organizing secretary, to kindly introduce the theme with our audience. Madam, over to you.
I'm here
Am
to
I
put it
audible,
at
sir?
okay. Thank you. Thank you.
Am I audible, sir?
Yes, madam. Yes, madam, you are audible.
Good morning to everyone. I am honored to address you today on a topic of critical importance, protecting AI intervention under current intellectual property. As we stand on the threshold of the fourth industrial revolution, the artificial intelligence is not just a concept of the future. It is a transformative force reshaping industry, economies, and our daily lives. From healthcare diagnostics and financial services to automobile vehicles and personalized marketing, AI interventions are driving innovation and efficiency across sectors. Together with great innovation comes the critical responsibility of protection, and this is the intellectual property law takes place. The intersection of AI and IP law presents both opportunities and challenges in front of us, for which a strategic approach to safeguard innovation while fostering fair and inclusive access to technological advancement. Today, we will explore the key aspects such as the ownership of AI generated work, the implications of AI in patent and copyright law, and the evolving landscape of AI driven invention. Understanding these complexities is crucial in navigating the ethical, legal, and economic dimensions of AI intervention under existing IP framework. It is my pleasure to inform you all that for today's workshop, we have a good number of participants from outside state states also, like Assam, Tamil Nadu, Uttarakhand, and West Bengal. So I look forward to engaging sharing discussion and gaining valuable insights that will continue or contribute to shaping the future of AI innovation and an intellectual property. So thank you everyone. Welcome.
Thank you, madam, for your insight and thought. Now, I would like to request Dr. Devashish Datta, convener of this seminar, to kindly introduce our chief guest with the audience. Sir, please.
Thank you, sir Subhash. So, first, good morning to the respected Father Principal, Dr. Father Benike John CAC. A very warm good morning and heartiest welcome to the Honorable Vice Chancellor, Sir, National Law University, Professor Yogesh Kumar Singh, sir, to Holy Cross College, Agartala, and the Department of History and I.Q.A.C, sir. We are very thankful to you for accepting our invitation. Now, it is my deep privilege to have an opportunity to introduce a stalwart like Professor Yogesh Kumar Singh, sir. I would like to start with the education qualification of Sir Yogesh. Sir did his LLB from University of Allahabad. Then Sir did his LLM in specialization of human rights from National Law School of India University. Then Sir did his PhD from National Law University Odisha. And Sir PhD got published in a book form entitled Judicial Dissent at Indian Supreme Court Enriching Constitutional Discourse. The foreword of this book was written by the current Chief Justice of the Supreme Court of India, the Honorable Chief Justice Dr. D.Y. Chandrachud. The research area of Sir Yogesh includes constitutional law, judicial process, access to justice, teaching pedagogy, public health law, reform in legal education. Sir is having international exposure in the form of participating in the 39th annual session of the International Human Rights Law organized by International Institute of Human Rights, France, and Sir was also an integral part of the CD program, France, which was conducted for university teachers. Sir is having a vast administrative exposure in the form of head school of law, local university, UP. Then Sir was also the deputy registrar research at the Supreme Court of India. Sir was also the registrar and vice chancellor in charge in the National Law University, Odisha. Sir is having vast experience in presenting and publishing his research articles in different national and international journals. And Sir regularly writes in the public domain, such as in the New Indian Express, the Statesman, Deccan Herald, the Tribune, the Wire, etc., etc. So it is just a tip of iceberg which I have represented in the form of the introduction of Sir Yogesh. I know all of us are actually eagerly waiting to listen from Sir Yogesh, not from me. So with this, I am concluding my short introduction of Sir Yogesh. Sir, if I made any mistake in introducing you, please pardon me. As consider me as I am your student only learning from you. With this, over to Sir Subhash. Thank you.
Thank you, sir. Now it's my privilege to invite our resource person and chief guest, Professor Yogesh Pratap Singh, sir, Honorable Vice Chancellor of National Law University Tripura, to kindly address for the gathering, sir. Sir, over to you, sir.
Thank you, Subhash ji. Am I audible?
Yes, sir, you are clear and
Okay,
audible, sir.
okay, very nice. So thank you very much. A very warm good morning to all the members of the organizing team, especially Department of History, and all the dear participants. I am grateful to Honorable Principal, Holy Cross College, and faculty members from History Department and various other departments for inviting me and giving me this opportunity to interact. I have visited your college last year, and it was very nice experience. The topic which has been decided for this workshop, for this seminar, is protecting artificial intelligence intervention under current intellectual property law regime. in my opinion, is also of utmost importance and very relevant in today's contemporary time, where technological interventions have permeated nearly every facet of our society, our human life. The depth of integration of technology into our daily life, everybody would agree, paints a reality where the digital realm appears to have submerged the real world, and the lines between the two are significantly blurred. The rapid development of emerging technologies like Internet of Things, IoT, or artificial intelligence, AI, big data, are transforming the future as we know, and these technologies become increasingly pervasive. We can look forward to time when our children will grow up with artificial intelligence and blockchain as a standard components of their life. So time is not very far. Our judges, I come from a legal background, so I give examples from legal system, from judiciary. Our judges of the High Court and Supreme Court, who are not from the new generation, so they are not that techno savvy, because these are old generation people, senior people. But we will be surprised when we know that our judges are also using artificial intelligence. So our Supreme Court, the Chief Justice of India, is very techno savvy. Some of the judges of Supreme Court are also using artificial intelligence. Some of the judges are also techno savvy, but majority are not. But as a matter of fact, now Supreme Court is using artificial intelligence all stage students are now familiar with chat gpt, and our judges are now also using chat gpt for delivering judgments and orders. In recent times, recently, some of you must have seen in the newspapers that some of the high courts have used chat gpt, and it was reported in the newspaper. Some criticized, some praised. One of the judges of the Punjab and Haryana High Court, in one of the cases, Jaswinder Singh versus State of Punjab, he used or he took assistance from ChatGPT in a matter pertaining to bail petition. You know, bail petitions are given to High Court, and the judge has to decide whether person will get should be granted bail or not. The case was dismissed, but one of the observations of the judge was made with the assistance of ChatGPT, wherein the judge wanted to know the worldview on the bail petition. Yeah, so judge wanted information that what is going on in the global platform about the bail petition. What is the jurisprudence, global jurisprudence, how US is dealing with bail petition, how UK is dealing with bail petition, how France and Germany is doing with, how other legal system like civil law legal system they are doing with bail petition. So he wanted this information and he took assistance from the chat gpt, and it was the paragraph which was given by chat gpt was quoted in the judgment. The chat gpt part of that judgment order was put in the post reasoning portion of the order. Post reasoning means the reasoning part was not given to chat gpt, so that was the original work of the judge. After giving the reasoning why he is dismissing the bail petition, he also supported his reasoning with the information which was provided by the chat GPT, where the court highlighted that the use of the generative tool was merely for the purpose of getting a worldview on the perspective of bail in cases of cruelty. So, how in cases of cruelty, different jurisdictions, US, UK, France, Germany, China, how they are dealing with the bail petitions, whether they are liberal, whether they are conservative, whether they are rejecting, whether they are accepting.
Same.
So, in cases of higher judiciary, High Court and Supreme Court, legal proceedings and principles of natural justice, which is another very important area which judges are supposed to follow strictly. The chat GPT is nothing short of an amicus curiae for the court. Amicus curiae means friend of the court. This is a Latin term, amicus curiae. The courts appoint several times in number of cases. They have appointed already amicus to a senior lawyer. So senior lawyer will be appointed amicus in a particular case to help the court. So he will do his own research and he will assist the court in the decision making process. So similarly, Chat GPT is also working as an amicus. Similarly, Manipur High Court in in a recent case, Muhammad Zakir Hussain versus State of Manipur used Chat GPT, Chat GFPT 3.5 and Google search to get information onto the working and service condition of the Village Defense Force VDF. And the court had initially asked the government to explain the procedure for disengagement of VDF, but there was no response filed in the counter affidavit. So initially the court asked the government of Manipur to give information that what is this defense force and why this has been being used or employed, but there was no information given by the government in counter affidavit. So court decided that we will do our own research because court has to give decision. The court has to take a call. So court decided to take this step to do research by its own from Google and ChatGPT 3.5, and this eventually helped the court to come up to a better proposition. In fact, it was the use of the search engine and generative artificial intelligence that the office memorandum came forward before the court, highlighting the service rules of the VDF. So, our high courts and Supreme Courts also, in number of schemes, they have already started using artificial intelligence. So there is no doubt on this aspect that this is an exciting journey. And as things continue to change, the legal system will need to respond accordingly. And because legal system will bring the order in the society. We have law, we have a statute, we have code for each and every aspect which a human being can imagine. So from cradle to grave, all dealing with all the human relation aspects of human life, you will find a law passed either by the parliament or by the state legislature. So when artificial has or is coming up in a big way, it is going to change our lifestyle. It is going to change our various aspects of life, our relationship. The legal system has to respond accordingly because our legal system, which was 50 years old, may not comprehend this kind of situation. Law is an organic document, law is an organic instrument. It requires change with the changing time, with the passage of time, with the development of the society. So, the involvement of technology in the creation of innovation is both necessary and unavoidable. Everybody would agree to that. Because for new generation, new age innovations is it has not only reduced, but in some instances practically replaced the quotient of human effort. And this is the purpose of technology. But this has, at the same time, this has also resulted in a unique problem where the new work generated through the use of software programs, algorithms, cannot be distinguished from those that result out of the human endeavor. We can't distinguish. This is because in the current industrial and market scenario, the clear ownership of intellectual property is of very important significance. It is of paramount for any individual or entity, which more often than not dictates the growth trajectory of a business. Ownership of this intellectual property is important. And while discussing this ownership, the biggest point of discussion, debate, and discourse today is whether ownership can be extended to a non-human counterpart. Whether ownership can be extended to a non-human counterpart. It may be software, it may be algorithm, which have contributed to the development of a product. Because in the traditional sense, in the traditional understanding, property refers to the relationship between a person and a physical object. My house is my property, my land is my property, which I can own, which I can possess, which I can sell, which I can decide terms and conditions that who will use my property and who cannot use, who can enter into my house, who cannot enter into my house. But now with the development of intellectual property, this old traditional notion of property is under change. Intellectual property refers to a legal protection of creative intellectual achievements. It is a fundamental aspect of our society that empower us to protect and benefit from our uniquely human quality, our intellect, our creativity, our inventiveness. And these qualities are so crucial that law grants us property rights as it was given to us on a physical property. Law has given property rights to these intellectual property to control what happens to our creation and to reap commercial benefits from these intellectual property. There is a organization called World Intellectual Property Organization, WIPO. WIPO defines intellectual property as unique value creation of the human intellect that arise from human uh, imagination, creativity, inventiveness. And this property right allows us to have control over our creation, much like what I referred owning a house, where we decide that who will come on our property, who can use our property, whom we can rent it to, and what color we should use for our property, our house. So by having these rights, we can ensure that our ideas are safeguarded and that we have the opportunity to profit from them. So if I have created something, I should get benefit. Society will get benefit. There is no doubt on that. But because I am the originator, I am the creator, I should get some benefit out of it. So these protections will not only benefit the creators but also will help to promote innovation, which will finally lead to the growth and development of the society. Growth and development of the society will depend on these creation and innovations, and that is why government is promoting innovation. So we have various intellectual property rights which are recognized under law, like copyright, which is a type of intellectual property that protects original works of authorship as soon as the author fixes the work in a tangible form. It is an essential intellectual property asset for artificial intelligence as it safeguards the technology product, including code, data, graphics, from unauthorized use and reproduction. Artificial intelligence often involve large data sets. An algorithm that can be protected by copyright as compilation of data, contractual terms with end users and third parties should specify the permitted use, but the ownership of this machine generated works is a very contentious issue. An agreement should attempt to clarify ownership where possible. Who will be the owner of this work? Patents Patents provide time limited protection for invention and can exclude others from making, using, or selling the patented technology. They may provide a competitive advantage and protect research and development investments. However, the artificial intelligence software is increasingly difficult to patent, and patent offices and courts across the world, I'm not saying it only in India, across the world, they are struggling with the clear delineation of what is patentable with respect to artificial intelligence. So can we give patent rights to artificial intelligence or algorithm? That is we are not yet sure, because legal system is not very clear on that. Similarly, trademark and other. So the current IP regime, intellectual property regime in India, is, and also in different parts of the world, does not have express provisions for extending recognition, much less ownership, to software and algorithm per se that are used to create IP eligible for statutory protection either under Copyright Act or under Patent Act or under Trademark Act. We find a limited exception under Copyright Act 1957 of India, which recognizes a person who causes computer generated work to be created as the author of the work. However, the non human counterpart means the software, the artificial intelligence per se cannot be assigned authorship of the work. Section 2D, subclause 6 of the Indian Copyright Act 1957. Indian Patent Act 1970 and Indian Design Act 2000 also do not have a specific provision to recognize a programmer or developer of an inventor as an inventor or owner of any innovation that results from operation of any software, AI, or algorithm. And this problem is further aggravated when the work or innovation is solely the result of the endeavors of the software, AI, or algorithm without any human intervention. There is no human intervention. Innovation is the sole creation of the software or artificial intelligence. Can we give them this ownership? So this is one of the biggest challenge when we compare Indian legislation with foreign legislations. We find that even the UK, we find some provision under Section 9, subclause 3 of the Copyright Designs and Patents Act (CDPA) of United Kingdom, which states, and I quote, in the sense of a literary, dramatic, musical, or artistic work which is computer generated, the author shall be taken to be the person by whom the arrangements necessary for the creation of the work are undertaken. Section 178 of the law CDPA of United Kingdom defines a computer generated work as one that is generated by computer in circumstances such that there is no human author of the work. Now, legislations of countries like New Zealand, Ireland have also inspired by the UK law CDPA, and they have also adopted similar changes in their domestic law. So while both the innovators and lawmakers around the globe, they are now coming to realize the lacuna in the legislations to accommodate and acknowledge non-human contributions, the attempt to determine the capabilities of a software to mimic humans in certain situation and its capabilities of making valuable contributions are not newfound. There is a mathematician who took a test, and this test was called as Turing test, Turing, Turing test. What is this Turing test? It is a test of a machine's ability to exhibit intelligent behavior. To exhibit intelligent behavior of a machine which is not distinguishable, which cannot be distinguishable from that of a human being. Now, in this test, a human judge, a judge, he will be engaged in the natural language conversations with both a machine and a human. Judge will be the umpire, like our court. So one side there will be a machine, and one side there will be a human being, and the judge will converse with these two without knowing which is which. So judge is not aware that this is a machine and this response is coming from machine and this response is coming from a human being. This is not known to, this is not told to judge. If the judge cannot reliably, he cannot distinguish between the machine and a human based on their responses. Now, based on their responses, the judge will have to decide. But if judge cannot distinguish between machine and the human being, the machine is said to have passed the Turing test, demonstrating a level of artificial intelligence that simulates human-like conversation and intelligence. Get the point? So this test, Turing test, focuses on the external behavior of the machine rather than its internal process, emphasizing the ability to imitate human-like responses. The question was the question of whether this mode of thinking is tantamount to human cognition has found resolution with the evolution of technology and the ascent of generative artificial intelligence developed in today's time. Yet the question of whether IP rights should be extended to such software or developers of such softwares remains inconclusive at large. Legal systems are not capable to answer this question. We are still exploring the broad spectrum of intellectual property consideration regarding artificial intelligence generated works. We have a report from in India. Uh, you must be aware that in Parliament there are various standing committees. So one of these standing committees, Parliamentary Standing Committee, in its report number 161, they have also discussed some of these issues related to artificial intelligence. And this report refers to the ability of machines and technologies to perform cognitive tasks like thinking, perceiving, learning, problem solving, and decision making. I have already given you examples that our courts, high courts and supreme courts, and very soon our lower courts will also start using artificial intelligence in decision making process. So there is a parliamentary standing committee report which has discussed the nuances, which has recommended that we should change our law. The current legal framework in India, whether it is Patent Acts of 1970, whether it is Copyright Act of 1957, does not adequately address the intricacies of inventorship, authorship, and ownership with respect to works created or innovated independently by AI, artificial intelligence. we I'll give you examples from Copyright Act 1957. As the technology advances, questions regarding the ownership rights of artificial intelligence and their software developers in the creation of copyright work have been is being raised in all corners of the world. Under the Indian Copyright Act 1957, original works expressed in tangible form, I already mentioned. Original work expressed in tangible form are eligible for copyright protection. The Copyright Act does not explicitly address AI generated content, but I gave you section 2D subclause 6 of the Act, which specifies that for computer generated works, the person causing the work to be created is considered to be the author. This provision has implications for AI generated content, leading to both opportunities and challenges. Recently, we maybe some of you must have heard this in the newspaper. There is a case called Raghav. In 2020, the Indian Copyright Office faced this issue. Uh, this was involving an artificial intelligence system which was named as Raghav, 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 and its attempt to secure copyright registration for an artwork. So it took one picture from one source, another picture from another source, and it created an artwork, and it was named as Suryast. And this was requested for copyright. Initially rejected for lacking a human author, the painting was later granted protection when a natural person was named as a co-author alongside Raghav. So this Raghav, artificial intelligence, created this painting called Suryast. Initially, the Copyright Office they rejected because they can't give copyright to an artificial intelligence. But later it was accepted when the person who was involved, who designed this AI called Raghav, he was added as a co-author alongside Raghav. But subsequently, a withdrawal notice was issued seeking clarification on the legal status of Raghav, highlighting the ambiguity surrounding artificial intelligence qualification as an artist under the Copyright Act. So this kind of problem is happening not only in India, this is happening in all parts of the world. Another crucial consideration is the manner in which such data is obtained. Most important that the data sets used to train artificial intelligence systems are obtained without contravention of law. So if somebody is using some data set to train artificial intelligence, and it data set has been obtained within the four walls of the legal system after taking due permission from the owner of that data, without contravention of law and in a lawful manner with express consent and approval of the authors of such work. And this issue has been highlighted in the recent legal proceedings initiated by various authors of certain copyrighted work in United States against leading AI platform. It was alleged that the artificial intelligence platform used a copyrighted work without authority. A balance therefore needs to be maintained and an emergent strategy to safeguard AI generated creation from claims of infringement, even when drawing inspiration from existing material, would involve categorizing them as derivative work. So it can be categorized as derivative work, particularly in the light of the fact that the Berne Convention, there is an international convention, old international convention, and 181 countries have signed this Berne Convention. And this Berne Convention is for the protection of literary and artistic work, which was signed in 1886. International treaty, which the object of this treaty is to provide a unified framework for the protection of copyright across participating countries, identifies derivative works in its Article 2, Clause 3 as a new creative work. So even a derivative work, if you treat that artificial intelligence work is derived from the existing material and it is termed as a derivative work, even that should also be protected within the framework of Berne Convention. And I have already mentioned 181 countries have signed this Berne Convention. So securing copyright for derivative works under the provisions of Berne Convention also mandates a visible and non-trivial departure from the original source. AI tools utilize data derived from existing sources. The resultant output is far from direct copy. You can't say that it is a direct copy. It is shaped by unique learning abilities of the AI model, and therefore the works created by AI cannot be said to be a copy, carbon copy. Okay? So you have to take a call. So while in current scenario, the Indian Copyright Office allows applicants of translated or adapted work, derivative work, to seek copyright protection by referencing the original works at the time of filing the application. In my opinion, this could serve as a foundation for requirement of referencing existing copyrighted works that are used to train artificial intelligence system to generate new copyrighted work. But the question of authorship still remains ambiguous, as it addresses the idea that creativity is purely a human attribute. So we are still going with this idea that creativity comes only from human being. But the question then will arise as to whether an AI system is exercising creativity while creating new works or is merely mirroring the style of creator who formed part of data sets that it was trained on. Indian copyright law has a requirement for strict human authorship. A work must be authored by a human being in order to be eligible to claim copyright protection. So while Copyright Act acknowledges creators of computer generated works, the legal status of AI generated content per se remains unclear. In addition, the general protection period for original works under Indian Copyright Act lasts for 60 years from the year following the author's death. If AI systems are granted authorship over work, now this question will come in future when government will decide that whether AI should be given this ownership right or not. So if AI systems are granted authorship over some work, the perpetual existence of artificial intelligence system challenges the fundamental purpose of the protection period, because this AI will continue to exist in perpetuity. So this question will also come. Another major hurdle that lies before the intellectual property community is enforcement of copyrights. Granting authorship rights to AI system, how it will be enforced, how AI will be held accountable for infringement, because AI system per se lacks legal personhood and cannot be held accountable for the infringement of any other or infringement or any other legal ramification. So again, a very complex scenario. Who will be accountable if there is an infringement of copyright by the AI? You can't prosecute a software, you can't prosecute a artificial intelligence. So these questions are being raised with respect to authorship, ownership, enforcement. And the Parliamentary Standing Committee report, which I referred, has recommended that a separate category for protection of AI based inventions as IPR should be introduced. The committee has recognized the relevance and utility of cutting edge technologies like artificial intelligence. So we can't say that artificial intelligence is not good and we cannot discard per se outrightly. Technology can will help or can should be used for the betterment of our life, betterment of the society. So we have to make changes in our legal system based on best practices, what is happening across the world. Our laws should also be amended. Similar example I can give with respect to patents also. I mentioned that Patent Act 1970 does not acknowledge, does not recognize anything like artificial intelligence, and that is why question being raised that can we give patent right to an artificial intelligence. Patent system, as you know, rewards the development of new and useful inventions with exclusive rights to exploit these inventions for creation for a certain period of time. In return, it requires the inventor to publicly disclose their invention so that other people can learn from it and continuously build upon the state of art. But this process of innovation is no longer the sole domain of human beings, human mind. AI is now generating creative outputs. AI systems like IBM's Watson, you must have heard Watson, and Google's DeepMind have already been deployed to solve some of the great technical, scientific, and medical challenges of our time. But this has also raised several questions, crucial questions. How the patent system will protect AI generated interventions? Is a system designed to foster human imagination and innovation sufficiently flexible to accommodate non human inventions also? Or should it be? What is happening in other parts of the country? The High Court of Australia observed, a constitution bench, 5 judges bench, that a valid patent may be obtained from something stumbled across by accident or remembered from a dream, so long as it is otherwise meets the criteria for patentability. So, why does it matter who the inventor is? The answer is ownership. Where the ownership lies, who will be the owner of that innovation. In most jurisdictions, a patent can only be granted to the inventor, means the person who are responsible for the inventive concept, or to someone who derived title from the inventor. Now, what is the global test? You must have heard now this phrase also, Dabus, DABUS, DABUS. The question whether an AI is capable of being named as an inventor of patentable subject matter is being tested across the world as part of the Artificial Inventor Project. And this project comprises a series of tests, patent applications filed by Dr. Stephen Thaler in respect of inventions generated by him. So means this this is a abbreviation acronym used for device for autonomous bootstrapping of unified sentience. Device for the autonomous bootstrapping of unified sentience. It is a type of connectionist artificial intelligence which uses multiple neural networks to generate new ideas, the novelty of which is then assessed by a second system of neural network. And by this process, Dabus has autonomously generated two inventions. So this artificial intelligence Dabus has generated two inventions in respect of which Dr. Thaler has applied for patent protection. The one was a fractal container, a food container, and the neural flame. Second was neural flame. And so far, with very few exceptions, the global trend in courts across the globe and patent offices across the globe has been to reject these applications. So he is filing patents application in various jurisdictions, and in most of these jurisdictions, these applications were rejected by the patent office, or if there is an appeal in the court, by the courts. Although the reasoning has varied from country to country, they have different reasonings, different questions, different concerns, but outcome is same, they have rejected. And the emerging global consensus is therefore that an inventor of a patentable or patented invention must be a human legal capacity. So either it should be a natural person or it should be a legal person. You know, legal person who is not a natural person like human being like us, but in the eyes of law he will be treated as a person. We call it legal person or juristic person. They have been conferred personality in the for the purposes of law. Like company, when a company is registered under Companies Act, it becomes a legal person. Its identity is different from the members who created that company, who promoted that company. And there are various tests to decide that who can be a legal person, who can be termed as a legal person. A person who can file a suit, a person who can sue or who can be sued, both. So if you can file a suit against somebody and somebody can file a suit against you in a court of law, then you will be a legal person. This is one test. A country may be a legal person because a country may be sued. The second test of legal personality, juristic personality, is that person can be conferred rights and person can also be imposed certain duties. So if somebody is capable of conferring rights and duties, then it can be given legal personality. Okay. So patent can be given only to a human or a person with legal capacity, legal person. And artificial intelligence has not been given legal personality so far. An artificial intelligence cannot file suit. You cannot file suit against artificial intelligence. Okay. So we have examples from Australia where a 5-judge bench of the federal court unanimously held that only a natural person can be an inventor. And it was in overturning an earlier ruling of a single judge. So ruling of a single judge was overturned, which said or which held that the meaning of inventor could evolve as technology develops and included an AI system also. So single judge was more progressive. But the 5-judge bench overturned the single judge bench decision in Australia. In United Kingdom, both High Court and the Court of Appeal agreed that the UK, United Kingdom Comptroller of Patents, was correct to refuse Dr. Theller's patent application on the basis that inventor had to be a natural person. And Dr. Theller had not shown a sufficient derivation of a right from an inventor. However, one of the 3 courts of appeal judges, one of the judges, Lord Justice Beers, While agreeing with the majority of the judges, he said that under Patents Act 1977, the term inventor meant a natural person and could not include an AI. Nevertheless, he disagreed over the correct course of action the comptroller should take, and he considered that the application should have been allowed to proceed to examination and, if valid, to grant patent subject to any challenge by third party. This is how law evolves. Now, see one judge in Australia, he was far-sighted. He was in favor of giving ownership right to artificial intelligence. Similarly, in United Kingdom, Lord Justice Bills, he was inclined to include or accept the invention, the innovation by the artificial intelligence. This is how law evolves in a country. Now, this will influence, this will open a debate, and this will evolve the law. Now, future judges, when this matter will again come up before the higher court or larger benches, then judges will read these opinions and they will decide cases. And this has happened in all the countries. The law has evolved like this. Earlier, it was a dissenting note. One judge said that no, this should not be happen. After 15, 20 years, it was recognized by the country, it was recognized by the parliament, it was recognized by the larger bench, and they accepted that the dissenting judge was right. The position in the United States is also similar. The US Patent and Trademark Office rejected Dr. Theller's patent application. So Dr. Theller has submitted application in almost all important jurisdiction countries for this invention created by Davos, stating that explicit statutory language used by the Congress to define the term inventor, such as individual and himself or herself, was uniquely directed to human beings. So language which is used in the Patent Act in US uses word individual, himself or herself, which denotes only human being, not an artificial person, not an artificial intelligence. Dr. Thaler was unsuccessful in challenging this decision in both the District Court and the Eastern District of Virginia and the Court of Appeals in the Federal Circuit. And US Supreme Court has also declined to hear the appeal filed by Dr. Thaler. So Supreme Court of United States is also not willing to accept this logic of Dr. Thaler's. Dr. Theller's patent application have also been unsuccessful in New Zealand, Taiwan, Israel, Korea, Canada, Brazil, and India. Okay. So this is how the legal systems across the globe is behaving with the emergence of artificial intelligence. It appears that our IP laws are not able to comprehend, because when it was drafted, when it was passed, it did not anticipate that this kind of situation will emerge. But now situation has come, so we should now respond. Now the question will also be asked that if not AI, then who? Because of the way Dr. Thaler argued the cases, none of the Australian, UK or US courts nor the European Patent Office was required to answer who if not Davos. ठीक है, आप Davos को नहीं पेटेंट दे सकते हैं. This Davos artificial intelligence which invented two things, then who should be given ownership? Who should be named as inventor of these relevant patents, which was created with the help of Davos? The Australian Federal Court suggested options. उन्होंने option suggest किया. The owner of the machine upon which the AI software runs could be given. The developer of the AI software means Dr. Teller. The owner of the copyright in its source code. The person who inputs the data used by AI to develop its output. But there is no conclusive answer. And we have to see the implications. We have to see implications. What is there in future? We have now seen that vast majority of patent offices across the world, vast majority of courts across the world have declined to recognize AI as an inventor. And therefore, it is important to note that for the most part, they have been addressing the relatively narrow question of whether Dr. Theller's patent application met the formal requirements of existing legal framework. Because existing law does not recognize, existing law has only comprehended natural human being or an artificial person who can be given legal personality. But these decisions have raised the broader question of whether and how the patent system should accommodate inventive contributions made by AI. That question is the subject of active consideration by the governments across the world. So they are already discussing. I have already mentioned, and that is why matter was taken up by Parliamentary Standing Committee. And Parliamentary Standing Committee has recommended that we have to accept, we have to recognize, we have to comprehend the challenge which has come up, and we have to see how best we can utilize this for the benefit of the society. So various jurisdictions, various countries, they are exploring options to expand the definition of inventor to include the human responsible for AI system that generates inventions, or allowing artificial intelligence to be identified as the inventor, or protecting artificial intelligence device invention by means other than the patent system. So these possibilities are being explored by various countries, including our country, because our country will have to accept. India has to play an important role in the world economy, technology, and that is why uh, government is also very concerned about the intellectual property regime, how it should be amended and how it should be changed to accommodate artificial intelligence. And because artificial intelligence is going to stay, it is going to change our lifestyle, it is going to change our relationship, it is going to change our working style, and our law has to address all these questions. So I think I should stop. I have already spoken, and thank you very much for giving me this opportunity.
Thank you, sir, for sharing your vast knowledge and expertise with us about the artificial intelligence and its growing need and demand across the globe, not only within India but outside, and various laws associated with the artificial intelligence and its intervention into intellectual property life. So, thank you, sir, for sharing your vast knowledge and expertise. Due to the shortage of time, the question answer session we need to cut short. We ask
You
our
you
student
you
to
you can take their questions if they have any concern, any question, any queries. You can email to me. I will respond so that you can send
Sure.
it to.
So we ask our participants to submit their queries and question in chat box, but I can see there is no query so far. So therefore, we need to proceed further. So we are at the
When
end
there
of
is no when there is no question, then we presume that either they have understood everything or they have not received anything. So both possibilities are there.
so probably this is there. Yes, sir. So hence we need to proceed further. Now I would like to request Dr. Shushuban Sengupta, Joint Convener of the seminar and I.Q.A.C Coordinator of Holy Cross College, to kindly deliver vote of thanks. Sir, over to you.
Thank you, sir. Respected dignitaries, esteemed guests, and participants, on behalf of the organizing team, I, Dr. Sushovan Sengupta, the I.Q.A.C coordinator of Holy Cross College and joint convener of this one-day online national level seminar, would like to express my heartfelt gratitude to each and every one of you for making this event a grand success. I always say that organizing an event uh, takes place only when there is a vision and an eagerness to organize an event. The success and failure of an event matters by the content of the event. And I feel the presence of the Honorable Vice Chancellor and his delivery have given us uh, immense opportunity to work with AI and the understanding of the AI interventions under the current IP law. Firstly, I would like to thank our Honorable Vice Chancellor Tripura for have given us huge information in a very short span of time. This
Sir,
lecture,
sorry for the
and I
intervention.
also believe that all the hello.
Can I leave? I have a class. So please, you continue. I will leave, and thank you very much for giving me this opportunity. We'll meet again.
Okay, sir. Thank you, sir.
Thank you so
Sir,
much.
Dr. Sir, I think your voice is not coming properly, sir.